I call the Honourable David Cunliffe.
Thank you, Mr Chairman. Mr Chairman, it's a pleasure to take a call in this committee stage of the Construction Contracts Amendment Bill. To note that Labor supports the bill, also note the presence of the Minister and the Chair, the Honourable Nick Smith, who we weren't at all sure was going to be able to join us for this, so we welcome him back to the Chamber. Mr Chairman, let us begin with the problem definition of why this legislation is being passed today and the options which were explored, the amendments which the Select Committee made and the reasons that Labor is supporting it, although with one or two minor reservations. Can I note before I get into it, this is the fourth bill in a row that we've had on committee stage where the Labor opposition has been supporting the bills. And so for members of the public, today is perhaps one of those days where we see the other side of Parliament in action. We see quiet cooperation behind the scenes in select committees, and we see work across the House, across all sides of the House, to try to tease through complicated problems and come up with workable solutions. The problem that we're seeking to solve with this Construction Contracts Act amendment is the fact that the original 2002 Act, we'll call it the Act, provides for essentially a different regime for adjudicating or arbitrating commercial construction contracts rather than residential. It has a two-stage process of adjudication or arbitration, and if that fails for low-value claims, the claimants in the commercial claim can go to the court and receive a judgment. Unfortunately, in the case of residential contracts, that two-stage process has not been available, and therefore the regulatory impact statement notes that people have gone to the court as a first resort, not as a last resort, thus imposing undue cost and delay on the system. So the second part of the problem has been where risk is borne in the construction industry. The construction industry is essentially like a pyramid, where the client contracts with a lead contractor who contracts with specialist subcontractors, an architect, quantity surveyor, master builder, etc. And underneath each of those, and particularly in the case of the building contractor, there are a large number, often several layers, many layers in some cases, of subcontractors. Risk tends to be passed down the system. And over time, professionals in the industry work their way up the layers of the system so that their position is more secure. Well, that doesn't work when things go wrong because the subcontractors or the subcontractors keep getting it in the neck. That's not fair. They are the most vulnerable. And so a second objective of reform here, as well as making the system more efficient and more robust and bringing more of the same opportunities to bear in the case of residential contracts than commercial, as well as commercial. The second objective is to ensure that risk is more fairly and evenly shared through the industry so that we have a process which is robust, efficient and fair. So, Sir, the Labor Party supports the measures in this bill that are designed to resolve and to speed up the resolution of disputes in construction contract cases. We want to see that more is done to ensure that subcontractors don't miss out on the money that they're owed when things go wrong, the so-called progress payments. And if we needed any further evidence of the importance of that issue, the Mainzeal case shows that subcontractors were hit the hardest when a construction company failed. Subcontractors are almost always last in the creditor queue and they miss out when money is held up. That's not fair, and we wanted to take action to ensure that it didn't happen again. We have developed two options, contractors' liens and statutory construction trusts, as a way of addressing the issue of subcontractor risk. In the first option, contractor liens, contractors would be required to retain a portion of the money that they owe. The second option is the statutory construction trust, where money would flow through a trust to ensure that subcontractors get paid first should a construction company collapse. Our solution would apply to significant commercial construction projects and would not interfere with contractors' arrangements. We'd also clarify and tighten the law to ensure that in the event of construction company failure, subcontractors could get access to their tools as fast as possible. Mr. Chairman.
The Honourable David Cunliffe.
Thank you, Mr. Chairman. I appreciate the opportunity to continue the exposition of this debate. Following consultation on these options with the industry, Labor put forward as an SOP in the name of the Honourable Clayton Cosgrove the requirement of retention money for commercial and industrial developments be held in a trust for the benefit of the subcontractor entitled to the money. The Minister has in effect piggybacked on Labor's proposals, adding provisions for retentions now to be held on trust in an SOP that he has put forward. So the SOPs that are before us include SOP 439 by the Honourable Clayton Cosgrove, released on the 17th of April, SOP 446 by Julianne Genter, and SOP 52 from the Honourable Nick Smith. The Cosgrove Amendment, or Cosgrove's SOP, inserts a new Clause 9B in the clause which would create a new Section 24AA, requiring retention money for commercial and industrial developments to be held in trust. The Minister's SOP provides provision for retentions, being money withheld by one party to a construction contract from money payable to another. So that's in effect the other option. Mr. Speaker, can I turn now briefly to the committee report? The Commerce Select Committee considered this bill at some length, and it has done, I think it's fair to say, a pretty comprehensive report given the size of the bill. It's turned its mind to, firstly, the purposes of the bill, to remove the distinctions between residential and commercial contracts, as I said, to extend the scope of the Act to apply to contracts for design, engineering and QS work, to remove the distinction between enforcement of payment determinations and those relating to rights and obligations which are not payment related, and to speed up and make more efficient the enforcement process, particularly for residential contracts, as we described earlier. So the committee first turned its minds to a range of provisions relating to adjudication. They were worried about so-called ambush claims and the tight timeframes that the Act set out. So they therefore changed by amendment, or proposed to change by amendment, a new Clause 13A, changing the timeframe from 2 to 5 working days. In Part 2.
Well, we're not on Part 2, we're on Part 1.
We're on Part 1. I'll restrict myself, you're quite right, Mr. Chair, to Part 1. So we'll leave to a further call tracing through some of the Select Committee's amendments, and I will return then to the final purpose of the bill, which is to ensure that the process is smooth, that the risk is fairly shared, and that the timeframes achieve the right balance between avoiding ambush and providing for a speedy resolution of complaints which are common in the industry. How common? Well, our regulatory impact statement indicated that the authorised nominating authorities under the current Act have heard nearly 700 claims under the Act since it was set up, nearly 700 claims, which are by definition commercial and don't extend to residential. They will be significant in quantum. They are important, and the House's time is well used in trying to improve this area of law. Mr. Chairman, I thank you for the opportunity to comment on the stage of the bill, and I look forward to further comment as we get into subsequent parts. Thank you.
For Brett Hudson.
I move that the question be now put.
The question is that the